This is why I love talking to you. Now we're getting into the nitty gritty.
I've seen firms that have agreed contracts with AI suppliers or with tech platforms more generally, that if they stopped and looked at the terms, there is no way on earth they would actually have signed on the dotted line and agreed to it.
This rush to implement technology is actually outweighing compliance.
One law firm that put transcribers onto all of its staff's devices, and the fee earners don't know how to disable it.
Where is the line? How strict do law firms need to be in order to comply?
And the real risk, what if your staff are using AI tools and you don't know about it?
What's your thoughts on that one?
So, I'm going to say something controversial. My firm
Innovation without compliance is just risk in disguise. As law firms explore the potential of AI, one thing is becoming very clear. You can't innovate safely without a compliance mindset. In this conversation, I'm sitting down with Peter Wright, Managing Director at Digital Law, a specialist law firm advising on digital legal issues. We unpack the uncomfortable truths law firms need to face about AI, data privacy, and digital tools, the hidden dangers of transcription tools and instant messaging apps in law firms, and why these tools must be vetted, and the risk of not doing your due diligence. This episode is an absolute must for you if you're running a law firm. It could be the difference between staying protected or facing reputational damage and serious fines. I think this conversation is absolutely vital for people to listen to, because there's so many things that you've said, like literally golden nuggets of information that could literally make or break a law firm in this AI revolution. So, Peter, the first time that we spoke, I remember we had this conversation about law firms using AI technology, and you flagged to me something that I didn't even think of, but should be quite obvious actually, which is compliance. And when these law firms are using these different softwares or tools or platforms, usually things that are not like a legal tech software, but maybe something that's like, for example, I'll say like WhatsApp or ChatGPT. And you said to me, this may not be compliant with law firms, but this really kind of made me aware of something. And I've actually been quoting you so many times since that conversation. So my question to you is, what do you think law firms overlook in terms of these regulatory compliance areas when they're trying to use these off-the-shelf AI tools?
Thanks, Holly. I mean, I think it's a really good question and a really good starting point, because I think a lot of firms, I think to a certain extent, just whereas they used to, we have to be so compliant in so many areas of their daily practice, for some reason, there's just a little bit of a blind spot when it comes to the use of technology as a whole, and then even more so when it comes to the fast evolving AI tools that are out there and suddenly being adopted. And I think sometimes there's an element of law firms will see another firm using something and thinking, that looks good. And one partner will chat to another partner, I saw you using that tool. How's that? Oh yeah, we think it's really great. Oh, right. Okay. I'll start using that. Almost sort of assuming that someone else has checked that this stuff is fine to use, and not thinking, maybe we need to just check from a due diligence perspective. Is this actually a suitable product for use when we're providing legal services to our clients? And that's always got to be the starting question. And as you said, law firms, we are in a highly regulated sector. And in fact, not just law firms. So lawyers, when you're working in-house and you're doing different things as part of your day-to-day role, there might be some systems that are being used by the rest of the organization that you shouldn't really be using when it comes to the provision of legal advice. What do I mean by that? Well, first of all, it's a matter of, are they properly safe and secure so you can guarantee confidentiality? That old chestnut of, is it properly a way of being able to ensure that you can guarantee and demonstrate that confidentiality? And of course, in law firm, you're having to think, well, can we make sure that all of our communications, all of the information that we are potentially putting into a system will truly remain confidential? Will it be spirited away to a server in a different country? Will it be spirited away to a server outside of the European Union? Will it be spirited off to a server in the US? If it is, does it follow the right data sharing agreements to allow for that to happen? Guess what? An awful lot of systems don't. So there are quite a few systems out there, quite a few quite big, snazzy systems that deliver quite useful services. So, for example, transcribers. We see transcribers quite a bit now. How often do you now join a video call? And sometimes there's as many transcribers on there in terms of automated systems recording the call as there are human beings. But are all of those systems necessarily compliant, or do they have the problem I've just hinted at in terms of where are the systems? And if so, if those servers that system is using are based elsewhere, what happens to the data? How long is it retained? I've seen some systems, when it comes to the use of AI, that quite explicitly say any information that you upload will only be kept for a matter of hours and then deleted. I mean, that's ideal, because really it's then showing, well, at least there is no long-term data retention here. So at least you can think, well, at least there isn't a long-term data risk, but then you still have to think about, well, but is it secure in terms of how I'm sharing that information? But crucially, it is then a matter of thinking, well, long-term, if you don't know how long it's being retained for, you've got to take a look very carefully at the privacy policy and the terms of that product to ensure that it demonstrates compliance, to ensure that you have looked and thought, does it tick these key boxes? And if it doesn't, that suggests it's not really going to be suitable for the provision of legal services. And, shock horror, you can then use this to amaze and impress your clients. So, for example, if you have some clients who are in, say, financial services, banking, insurance, other highly regulated sectors, so pharmaceuticals, medicine, education, health, guess what? They may also have similar duties with regards to confidentiality and making sure they are looking after their potentially data related to, say, patients, clients, customers, third parties, and maintaining a duty of confidentiality too. It's just that we have to think about this because, with regulators such as the SRA, obviously they are not going to be able to respond in a particularly positive way if they find that confidentiality has been forgotten. Indeed, they tend to have a bit of a sense of humour failure on that point. So the point I'm getting to is you've always got to demonstrate that you have thought about this stuff. I've seen firms that have agreed contracts with AI suppliers or with tech platforms more generally, that if they stopped and looked at the terms, there is no way on earth they would actually have signed on the dotted line and agreed to it, and sometimes found themselves in really restrictive contracts and agreements with different tech platforms. And you think, you wouldn't advise a client to do this. Think of all the detail we go to on the average real estate transaction, pointing out every possible pitfall and snag on a transaction. Well, if we can do that for our clients, why aren't we doing it for ourselves? I don't know if it's, we don't understand these contracts. They're too technical, so we'll just click and hope for the best because we know that others are using it. I can't square the thought process, but as I say, this is the level of detail we should be applying, to be honest.
I've wasted hours drafting contracts in my business. I've used clunky templates, even written from scratch, looked into paying lawyers. I've even tried ChatGPT, but it just didn't hit the mark. I knew there had to be a better way. And then I found this, Air Counsel, an AI contract drafter built by lawyers for lawyers. I spoke to the team at Air Counsel and they use it for their own legal work, and they're improving it every single day based on real life feedback. It actually does the heavy lifting for you. It researches your jurisdiction's laws and nuances and picks up local drafting quirks and even matches your tone and style. It then builds a ready-to-edit Word document with hyperlinks, numbering and a table of contents. It's so quick. I was so impressed when I used it. What I love about it is you can ask it to draft any contract you like, and it will even give you suggestions for appropriate terms or clauses that you'd never even think of. If you're still spending hours drafting contracts the old way, you don't have to anymore. This changed everything for me. If you're a lawyer, business owner, service provider, it might just do the same for you. And Air Counsel have been kind enough to sponsor this episode, and I'm so excited to spread the word. It's the most sophisticated contract drafting software I've used. To get your free 7-day trial, just go to the description of this episode. Give it a go, and don't forget to let me know how it changes your workflow.
Same care that we have for our clients, we should be doing that for our own firms.
Absolutely. Especially because, obviously, as we mentioned, the legal industry, law firms are regulated by really strict regulators, as is the accountancy industry and other industries. And it doesn't make any sense to me why law firms wouldn't think more deeply about these exact areas, because it could do so much harm to them, not only from a reputations perspective, but from a monetary perspective. Do you think that law firms are potentially thinking like, okay, in order to keep up with my competitors or whatever, I need to implement the latest tech, AI. I need to look like I'm forward thinking. I also need to find more efficient ways of working because I've got this pressure on me. And this rush to implement technology is actually outweighing this look on compliance. Do you think that this could be what's going on here?
Yes, I think there is very much the sort of a pressure to be seen as an early adopter, a pressure to sort of keep up with others. So it's like if you see a competitor or whatever, or as I say, partners in other firms saying, "Oh, we're using this, we're using that," and you want to be able to say, "Well, actually, yes, we've jumped on the bandwagon and we're using this, this, and this, and it's really helped us," and to have a positive story to talk about there in terms of tech adoption. And I think sometimes that's meaning that perhaps because they don't understand it, partners and directors are saying to their IT teams, "We'd like a system that goes and does this. Please go ahead and do it." And then they're sort of empowering IT, thinking, "Oh, this is the best thing." They don't want boring oversight from us. We won't understand what it is they come back with and ask about anyway, so we'll just tell them to go and do it. And this literally then leads to these sort of sometimes quite restrictive terms being agreed to, and then you suddenly find, as I say, that you're locked in. And I've spoken to people within the legal tech industry, indeed sometimes people who've worked with some businesses and then now left, and they're then sort of free to say what they really think. And I know that there are some platforms out there that are specifically aimed towards law firms and don't particularly provide good customer service, have these, as I say, these incredibly restrictive contracts. So if you jump through the right hoops and apply on the once a leap year, there is the window when you are able to actually get out of the contract. If you do that, then they'll charge you huge amounts of money, like thousands of pounds, just to be able to leave. I'm talking here more about sort of generally tech as opposed to AI, but the point is that we seem to have got to a point where these quite restrictive contracts are being foisted on law firms, and law firms are finding themselves dealing with them and then thinking, well, what do we do? And therefore, it's a matter of, as I say, having that proper due diligence. And if this is happening, if you're finding yourself in this position because there wasn't that level of scrutiny applied, and it was just, oh, we told the IT to go off and do it, and they set up the system and we never checked. Well, this is where you do need to have that level of oversight, I'm afraid. You do need to have lawyers working closely with the tech team to make sure, well, what are these terms? What are we signing up to? How do these systems work, for example? I know of one law firm that put transcribers onto all of its staff's devices, and the fee earners don't know how to disable it. So therefore, it's running in the background of the device all the time. So I started talking to a friend of mine who works at a firm. This transcriber turns up, and after we'd talked about a client on the call earlier on, client leaves, and then of course he starts talking to me about just general stuff, family, holidays, weekends, and I'm like, this is all going on to your recording now. I'm not really sure you'd want that to go on there. So I'm like, do you have to switch this off? And he says, oh, no, I've got no idea. So because it was on my firm's video conference platform, I ended up just booting this thing off and getting rid of it, excusing it from the meeting. But I think that's a bit of a problem if your own staff don't know how to disable these things. And indeed, if your own staff haven't thought about the privacy and security implications there. If I say you're talking about sort of personal stuff, but what if that involves your childcare arrangements? What if that involves potentially, say, custody arrangements? If it's like, oh, I've got the kids for this weekend and we're going to go and do this, blah, blah, blah. Well, okay, great. But there's actually quite a lot of personal data and potentially sensitive data in there. And if this is all being hoovered up and then, as I say, going off on some insecure system off in California, that's not really very particularly great, is it? And what I'm coming round to say is that this is where firms need to think quite carefully about, well, what's your policy going to be on this stuff? We work with a lot of our clients on setting up AI guidelines so that staff know we have a framework in place which we will follow when it comes to the use of AI. They will deliver training to staff on how to use these systems, why they're using these systems, making sure that staff don't think, oh, I want to circumvent this because I don't like it, and explaining, well, no, this is here to actually save you time, and this is the reason why we've done it, and therefore it's great if you could use it, and this is how to use it. But otherwise, you can get into real problems. As I say, you get staff might circumvent it. They might not know how or when it should be used, and might be using it on the wrong occasions. And the real risk, what if your staff are using AI tools and you don't know about it? What if they've started using, something like ChatGPT for drafting certain letters, and they're just not asking it to do a few paragraphs? What if they're dropping in information, Mr. Davis of 34 Acacia Avenue, ChatGPT, please draft me a letter to do blah, blah, blah. Even if it's like a covering letter to something straightforward and tedious, no advice in there, but they're using that to save time.
Yeah.
Have you told them not to do that because of the issues around personal data? Are they using a transcriber? Are they using certain systems that, as we say, would not actually be compliant, but they're using it because it's a time saver, like, say, a grammar checker? How many people don't want to sit there and work out typos and, what's wrong? And they could be using something that, again, is not properly secure. And guess what? A lot of those grammar checker bots very often rely on AI. Very often, guess what? They're looking at all the data, in particular if you've got those embedded ones that you can actually have embedded into Outlook or your email platform of choice. Guess what? They might not be entirely secure and therefore not necessarily compliant. And you may find, if the worst happens, you're in a legal and regulatory breach position.
Whoa. This is why I love talking to you, because you just know everything. It's so interesting. And now we're getting into the nitty gritty. It's funny what you say about these transcribers being always there, because I remember my friend telling me that when she joined like a top law firm, I'm talking like Magic Circle law firm, one of the first things they told them like years ago was be very careful about what you write in an email, because there's a risk it could go on the Financial Times. If you don't want it to be on the Financial Times as like a headline, then don't write it in an email, basically, because it could, basically they're insinuating it could be leaked, or someone could tell a reporter, or like, something like this, right? But what's very interesting in terms of what you're saying is, they've got these transcribers going on in the background and potentially sharing really personal information if people don't know how to turn them off. So surely law firms need to be thinking about these massive risks to their reputation, above everything else, I would say, because these things can be leaked. These personal details can be leaked.
Exactly. I mean, it's the old story of, whatever you send, would you be happy with a judge potentially holding up a copy of it in court and saying, or trying to infer a conclusion from it? Was a similar thing that was always one thing in a firm where I used to work. But it applies in the same way. If you end up saying or doing something that you wouldn't want referred to in a court, in a tribunal, or in that instance plastered on the front page of the FT, well, best not do it, eh? But the point is that this is where it gets quite interesting as well in terms of our modern way of working. When I first entered practice, we ended up, huge amounts of email, and that's still there. Lawyers love email because you can search your inbox, you can see what's been sent, what's been received, it's all in there, and you can copy in far more people than you have to, so you can cover yourself. So we've always loved email for that reason. Fast forward, though, where are we now? Instant messaging is used. Most organizations have some form of instant messaging, be it WhatsApp, be it Slack, be it Signal. Because we've got people that now work from home, how do you get in touch with them quickly and easily? You'll probably have some form of instant messaging. It's not even work from home. Sometimes it's just, it is easier to ping the person working 20 foot away from you through an instant message rather than actually walking up and having a human conversation. It's still the way I know that happens in some firms. But it means that we now rely on putting an awful lot of information in writing that previously we wouldn't have done. That's before you then get into, now we've got the notes from transcribing. transcripts that come through or automated from some of the conference call platforms as well. So we've got huge amounts of this data washing around organizations in a way that 30, 40 years ago, it wasn't. It was all in hard copy, and then it was put on the file, and after 7 years, it was shredded. So you didn't have this sort of farming of vast amounts of data, and then the risk of, well, what happens to that? So the point is that we've got all of this information on all of our mobile devices, and then you start throwing on different apps, some of which are exceptionally intrusive, particularly on mobile devices that you might install. And guess what? That means that you've then got potentially that very important information that should be confidential, secure, might be legally privileged, etc., potentially being looked at by various different apps. So, if you've got your email system on your phone or one of these secure messaging systems, he says secure in inverted commas, because many of these things then are looked at by other invasive apps that might be on your mobile device. So you've got to think very carefully about, well, what information there could then potentially be looked at by other apps, and then that blows apart that element of confidentiality. Now, the thing is, there are some really good tech platforms out there and providers who've actually spent huge amounts of money and resources putting together secure platforms so you can have a secure place on your mobile device for all your work-related apps that then will not be under scrutiny from, Meta's apps that are in the corner looking at absolutely everything and anything. But very often I talk to firms and lawyers about this, and it's going to be very expensive though, and we don't have to do that, and we'll just give our staff a business device and we'll do it that way. That is the ideal way of doing it, but if you're going to do that, you're then going to pay for expensive all-you-can-eat data so that your staff can work remotely using that at all times. And are you sure they still aren't then going to download different apps, and are you totally locking down access to that so that nothing can potentially look at it? This is before you then start to think about, well, this is where you need to have those guidelines in place around what is or isn't installed onto a mobile device. And then it also goes into, well, are you working securely as well? So we talked about working from home, working remotely. An awful lot of mobile devices now end up recording inadvertently what you're saying, hence your home smart speakers. And then increasingly, we're using that sort of information, those sort of things to actually record what we're saying. I mean, say you're in the car and using Android Auto. Guess what? That now, by default, unless you've asked it not to, they're starting to use AI to summarize what you might be saying if you're sending a text. So, that would then mean that you could then again be having problems with regards to confidentiality. So that's sort of all coming through to thinking you've got to think very carefully about the full sort of estate in terms of tech devices you're using each day and where that is then gathering and storing data.
But what's coming to my mind is there's so many different risk factors, being in the car, working next to your Alexa, working with your phone, speaking to a colleague on WhatsApp instead of Teams or whatever, like literally so many different things. Where is the line, in terms of how strict do law firms need to be in order to comply and be within the realms of what the SRA and I guess the ICO look for?
I think it always comes down to, as an organization, are you able to demonstrate compliance? Can you provide evidence to the regulators that you've looked at the risk, you've identified it, you've thought, how do we minimize that? And then you've put steps in place to do that, and then you've documented it. Now, that's the same approach that we follow when it comes to compliance as a whole anyway. That's what we're doing when it comes to AML. That's what we're doing when it comes to broader, our broader requirements when it comes to our clients and the provision of legal services. So we're used to doing this. And why we tend to have a bit of a black spot when it comes to use of tech and use of AI, I can't really answer that, but that has always been a problem. I don't know if technology gets put into the box of this is too difficult, or it's too all-encompassing. I can't be entirely sure in terms of why that's the case. I mean, the number of lawyers who come up to me, and this has happened, I've spoken at about 3 or 4 conferences in the last couple of months. It's been that usual conference season. And the number of times people come up and say, well, that was really interesting, but it's very scary, isn't it? Well, why is it scary? And if it is scary, well, why not do something about it so it doesn't get scary? But instead, people tend to think, oh, this is really scary. I'm going to put this in a box, I'm going to close the lid, and I'm going to forget about it until the next time I read about someone being fined or something going wrong, or the next time I hear someone talking about it at a conference or on a podcast. And then I might think about it again then, And then I might have a conversation with a colleague about it, and we'll both agree that it's too difficult, and we'll put it back in the box and forget about it again. I'm hypothesizing. I presume this is the process that people follow, but that seems to be the case, because I end up speaking to so many people at law firms and lawyers about, well, these are the risks and this is how you need to kind of close them down. But there's a look at, as I say, there's a look of, oh, this is just simply too time consuming, too expensive, and we'd rather just do nothing and run the risk.
Yeah.
And increasingly, we're seeing, when you look at enforcement from the ICO, and we have had another law firm fined recently that didn't report a data breach within 72 hours as they were supposed to. They instead waited about 6 weeks because they decided they knew better than what the law says and thought, oh, we've been on the receiving end of a cyber attack, but oh, well, actually they didn't. We don't think they took any of our data, so therefore it's all right. Therefore, we don't have to report it. When actually the law doesn't say that. The law says if someone else has had access to your data, then you report it. But they thought they knew better. They didn't report it. And then a load of client data appeared on the dark web. And even then, it took them a couple of days to work out, should we report it to the ICO? So the ICO had a bit of a sense of humour failure on that and fined them a lot. It was a significant 5-figure fine that ended up being applied there.
Oh gosh. Yeah.
Rather than, oh, what are we going to do to minimise the risk and look after and support our clients? Instead, it was, how do we get around not reporting this? That's not the right approach to take. If in doubt, report it. The vast majority of times, you report something to the ICO, they say, yeah, thanks for letting us know, we'll keep an eye on that. Whereas, oh no, if we keep it all nice and quiet, no one has to know about it. Well, yeah, guess what then happens when the regulator does find out about it? When we're talking about, well, what is the regulation when it comes to the use of AI in the UK? There is no there's no AI Act that applies. The EU AI Act doesn't apply in the UK, but all the government says is you should comply with UK data protection law. Okay. So it shouldn't be a high bar. But then a lot of firms seem to be somewhat confused in terms of what UK data protection law actually is. People keep quoting GDPR back to me, and it isn't. We have the UK Data Protection Act. We have the UK Data Use and Access Bill, that's Data Use and Access Act that's just been passed. How many people are up to speed on what's in that, which changes the law? Are people following the UK enforcement of its Data Protection Act, which means that progressively, month by month, year by year, the UK is diverging from the European Union? So, it's just to say, oh, all we have to do is comply with GDPR. No, there are specific things you need to comply with and demonstrate that you're complying with in order to show that you're thinking about the compliance of the tools that you're implementing.
Oh my gosh, information overload. There's some brilliant points there. I do want to pick your brain actually about a post that I read today. I want to know what your thoughts are. So I read a post that said that law firms are basically being reminded / prompted to use things like Copilot, Microsoft Copilot, in their day-to-day practice. What's your thoughts on that one?
So, you know what? First of all, I'm going to say something controversial. My firm, we do not use Microsoft products where we can possibly get away with it. So, no Microsoft 365 subscriptions and no constant mithering to use their cloud or therefore their AI products either. They aren't designed to comply with the EU or UK regulatory framework. The reason they're widely used is because, guess what? One of their major customers in the UK is the UK government. So there's a thought that, well, if we carry on using this, there won't be a problem. That doesn't mean that when we're looking at law firms and you're in a highly regulated sector, does that mean that you're necessarily demonstrating full compliance when you then look at a lot of the potentially risks and grey areas around the use of Microsoft products? And once you're aware of those risks, which of course we as a firm are, I find it very difficult to then say, oh, well, we'll sign it off and we'll use it anyway. That's a partial answer to your question. And then also you're saying specifically, well, with regards to Copilot, and this is unfortunately one of the things with Microsoft, they foist these things onto you. You didn't necessarily want, need, or ask them. I mean, who remembers little Clippy in the corner of your Microsoft Word document? Hi, it looks like you're writing a letter. Can I screw it up for you? Well, they're still doing that 20, 30 years later. The point is that they're always wanting, oh, please use this. In fact, we're going to start using it, and you're going to have to use this unless you specifically opt out of it. broadly, that some of these tools are okay to use. As I say, my firm, we have a particular aversion to this stuff, in particular Microsoft. One anecdote, we did some training for a government assembly, is as far as I can go on that, because it's confidential in who our client was. But we did a tabletop exercise. They'd been on the receiving end of a cyber attack. They wanted us to then go through and say, well, what do you need to be doing? So we then took them through a tabletop. If you hack, this is what you need to do. And we identified a vulnerability in that, but all their primary systems were all based on Microsoft 365, and then they didn't have any practical, meaningful backup either. They just trusted that Microsoft would never go down. And we therefore had a fairly direct exchange of views on that, because they were convinced that meant they didn't have to do anything else. A couple of months later, Microsoft went down last year. Do you remember that? When it was because of a patch on certain systems, loads of Microsoft-based systems, banks, airports, etc., went down for a prolonged period of time. They came back after that and said, oh, we see what you meant now. It's like, yes, exactly. So you might think that, because it's Microsoft, it's great, it's compliant, it'll always be there. Well, it isn't always necessarily there. And it doesn't necessarily demonstrate the best compliance. I would always recommend getting good AI tools that are specifically designed for the purpose that you need them for, and there are some really good ones out there. You only have to go to the some of the great conferences that are out there from either Legal Geek or the British Legal Technology Forum, or Legal Geek Growth, or Great British Legal Offsite, where I was last week, and you'll see some great suppliers there who are designing things specifically for the use in the provision of legal services. And then it just comes down to still carrying out that due diligence. Just because someone exhibits at a conference or has a snazzy stand or has a man in a smart suit saying, here's a brochure and isn't our system great, that doesn't mean it's necessarily fully compliant. You are responsible for your own due diligence. Don't presume that just because there is a very nice, smart, glossy brochure that, that's been done and it's all smart and it's all fine. So still do that due diligence, but look at specific systems that are designed for you and the provision of legal services. That would be my overall guidance on that. And I would be wary of where, as I say, Copilot ends up being inserted into things that you wouldn't necessarily have wanted, needed, or asked for its input on. And ask yourself, is this actually saving me time? Is it a good tool to help on that? Or actually, is it kind of getting in the way of just getting on and doing what we wanted to do? Always ask yourself that, is this actually helping me from a productivity point of view? If it is, great, and perhaps use it, but then have some clear guidelines in place around its use. So it's only used for that purpose, and you don't let that extend or sort of bleed further on than it should be used.
That's super helpful. I mean, my thoughts were not as detailed as yours, and I I don't think about Microsoft too much, but my thoughts were, to me, in my mind, Copilot is quite similar to ChatGPT. And so when you're using these types of things, you have to be so careful with the information that you put into it. Like you were mentioning, drafting a letter or whatever, even if it's a cover letter, if you're putting personal details in there, you need to be very careful. And like you mentioned, it doesn't come naturally to everybody. We should say that data protection or confidentiality should be at the forefront of their minds. For me, it is. For you, it is. But for some other people, it's just really not. So they don't really think when they're putting personal information into something like ChatGPT or Copilot. Do you think that law firms, I mean, I kind of know the answer to this actually, but I think you'll be able to give me a more detailed one. But do you think law firms should, as a non-negotiable nowadays, have an AI policy in their firms?
Yes. So this is an interesting point. I think when you you're saying to the average lawyer and you start talking to them about AI, I think they have a bit of a preconception in terms of what it is you're talking about. They'll think that when you talk about AI, you mean chatbots, or you mean generative AI that you can use to make nice, interesting pictures of cats doing different things. And very often they aren't thinking about those more sort of ancillary things. As I say, the transcribers, the grammar checkers, the device that you're using, in your car to have your text messages read to you, and that is then when you're speaking back, could, as I say, also be using that. So are you necessarily always thinking about that sort of broader use of AI? Because of a lack of understanding, that means that sometimes they aren't thinking about, actually, this is it, use of AI, I need to think about that. So in other words, yes, all firms should have AI guidelines as part overall of the documentation that we have to have in place as regulated entities, as law firms. So, we already have policy. We all have detailed policies around how we handle client money. We all have detailed policies in terms of the standards we expect to see on our interactions with our clients and setting up that solicitor-client relationship. We're used to having all of this governance in place. And it's just a matter of extending that a little bit when it comes to AI. And this is an approach that I've, been advocating for the last 10 years when I co-authored the Law Society Cybersecurity Toolkit. With that, we were saying, just make your cybersecurity compliance an extension of the day-to-day compliance that you're using. So if you're auditing a file, here are a few extra questions to add on to your file audit that are around cyber and thinking about the security of the communication and how you're communicating with your clients and what risks there might be and has it been followed. So if you've got to go through that audit process, we're saying extend that by about another 60 seconds. That shouldn't hopefully seem too difficult, but it's in the same way of if you're already having to jump through certain rather onerous hoops when it comes to compliance anyway, just add on a little bit more. So we're not saying go away and reinvent the wheel and have some really terrible, difficult to follow, difficult to understand AI guidelines in place for your firm. We're just saying add something into your firm's handbook as a whole that says, well, this is our approach when it comes to the use of AI, and this is what we're going to follow. And then, we're not saying, oh, you have to, the minute that you bring on your new staff for onboarding, that they have to sit through 2 hours of training on AI. Well, no, at the moment, you probably take them through some of the general things around your firm and your values and what you do and show them the handbook. And part of that is, this is how we use AI. So as I say, we're not looking at hopefully reinventing the wheel. We're not wanting to say that this is difficult or putting barriers in the way of your technical adoption, or we're not saying this has got to be incredibly expensive to do. It's just part of that overall approach to compliance.
That makes total sense. And I think you're right. There needs to be some type of mention in there because now AI is just so heavily used, even if it's just as simple as, like you say, a spell checker or ChatGPT. Most people use ChatGPT. So there needs to be something for law firms in order to make sure their employees are, I guess, on the same page as them.
And to a certain extent, it's a matter of saying, yes, we've got that in, we've got that in place. And then talking to staff, explaining and saying, well, like you say, if they are using ChatGPT, explaining what tasks it should be used for. If you want it to help you with a post on LinkedIn, if you want it to help with more sort of general admin tasks so that you can get those out the way, well, think about what you're happy for that to be used for and give staff guidelines on that, but then make it quite clear what you shouldn't be using it for. And also talk about talk about the pros of using it and the cons. Think about the fact that unfortunately, AI can do some of those straightforward admin tasks, but think as well about the fact that certainly the freebie versions of some platforms, they are hallucinating. And some of them are hallucinating in increasing volumes. So in the same way that you would sit down and scrutinize a bit of research that a human being does for you, do not assume that just because it's come from ChatGPT that it's all perfectly fine and okay and safe to use. Because guess what? I'm continuing to see headlines about firms sometimes relying on research that it has come through from ChatGPT, and it's totally fabricated different cases and made up citations, and then lawyers have looked at it and relied on it, and then they've only realised that it's all gone wrong when they've been in court and someone said that case does not exist. You'd want to find out before you find yourself in court, really, wouldn't you?
Yeah, definitely. I want to ask you, let's say you're a law firm, you don't use any AI or technology, but you want to implement it and you want to use something like, for example, Harvey or Legora, something like this. Where do you start with, I guess, doing your due diligence and making sure that this software that you choose is trusted, reliable, and also compliant?
So it's a matter of doing the basic wading through what might be some rather dry terms and conditions and a rather dry privacy policy. But it's worth doing it to establish the baselines in terms of how this system is designed and operated, what data it collects, how long it collects it for, where does it go, what's it specifically designed for. Make sure you're designing something, you're procuring something that is actually designed for the function that you're wanting it to undertake. It really is a matter of just starting from that sort of basic position, doing that rather dry and what could appear fairly tedious due diligence, and really starting from there, and then working out your questions that you might, having looked at the terms and the privacy policy, you might then have questions that you want to ask this supplier. And usually if you sit down and show an interest and start asking, they're actually really excited to be able to tell you about how their system does comply and how they have done it. So with a lot of those recognized systems that have been designed in partnership with firms, and sometimes that may have benefited from being, in the SRA's regulatory sandbox or the ICO's regulatory sandbox. Who knows what you'll be able to find and learn, and that actually becomes a selling point then for your use of that technology potentially with your clients, to say we've started using this system that's and it, actually talking about some of the due diligence, and if you've carried out something like a privacy impact assessment on it, great. I'd be wanting to actually tell your staff about the lengths you've gone to, tell your clients, so that you know that not only is it safe and secure, you've then got a full understanding of the benefits that you'll reap from its use. So this shouldn't necessarily be a sort of a sinkhole in terms of time and resources. What you're doing is actually investing, by taking this step, you're investing in your future sort of marketing and your future training to your staff and upskilling them as well. So this shouldn't be seen as, oh, this is an expensive thing we've got to go through, it's going to be time consuming and you're just going to get in the way. Well, no, this is actually part of a really important exercise for your firm. Because the other thing as well is each time with each big piece of tech procurement, it should be a lessons learned. So at the end of it, you're then turning around and saying, well, what worked on this and what didn't, and then learning from that when it comes to the next exercise. So it really is worth thinking very carefully about the use of different systems. And yes, there are some out there that, as you say, the Harveys, etc., of this world that have benefited from partnerships from big law firms. But I've worked with a few legal tech suppliers that are putting together really interesting, innovative platforms that they might not have benefited yet from huge amounts of VC funding or partnerships so far, but they're just, if you find the right platform, sometimes they're actually quite keen to then start working with more firms, and you might get a good deal. You might even be early on. They'll think, great, you can actually help us with the development of this product or platform and shape it more to what you then need as it's then sort of rolled out to more of their customers. So the point is that you can actually, yes, you can work with some of those big established platforms. There are sometimes some really good, as I say, small and startup ones where you can actually have some really rewarding and positive exchanges with them if you go into it asking those similar sorts of questions to what we've talked about in terms of where data's going and the security protocols and how they demonstrate compliance and what mechanisms they've got. And if any developer is worth their salt, they've thought about this. But by asking the question, you're then going to expose the ones that haven't. And unfortunately, there are big examples of this. I mean, don't forget, we had the CTS ended up going down that had about 80 different law firm customers almost 2 years ago now. If you actually sort of looked through their terms said, we will not accept any liability if this system goes down. So that's your giveaway that, well, hang on, if you're telling me that if you're hacked and I lose access to all my client data, I can't do anything about it, and you accept no liability. Whoa. So this is again coming back to that principle. If we saw one of our clients about to sign a contract like that, you'd be going, oh, no, don't do that. Yeah. Dozens of law firms signed up to a contract that said exactly that. And then when the worst happened, what do you do?
Wow.
So, we'll always look at that. Unfortunately, there are people out there who would try terms like that to try it on and see what they get. But, if, as you can imagine, if you find a platform that's saying that tells you rather a lot about that platform and tells you might want to look somewhere else instead.
It's a red flag, we say. I think this conversation is absolutely vital for people to listen to, because there's so many things that you've said, like literally golden nuggets of information that could literally make or break a law firm in this AI, I'm going to call it revolution. So I just want to say thank you so much for being so open about everything you've said, because I think it's going to be so valuable for law firms. And it's just super insightful and very interesting for me. It's just completely opened my eyes to so many different things. And as I say, I quote you on a weekly basis.
For those that are interested, I do produce a digital law podcast, which I suppose might be a little bit anarchy, and occasionally is just a man getting a little, screaming at the moon, talking about issues around tech and compliance and AI. But if this conversation has sort of struck your interest in that, and you want to hear about, what's the regulatory breach of the week, who's been hacked, what do you learn from it, what went wrong, what should we be doing, we try and produce a new episode on that every couple of weeks. And our most recent episode is a nice summary all about that Data Use and Access Act that I talked about, that's just been signed into law and is now going to be rolled out. If people are interested in that, just search digital law on Spotify or Apple or your podcatcher of choice.
Oh, nice. You failed to mention this to me last time we spoke. I will be tuning in.
Well, if people find the podcast interesting, I've also been working with a colleague on a Substack. In the past, we've put out books on this sort of thing. And then we thought, maybe people don't want to necessarily sit and read a book, or they find that, again, a little bit scary or off-putting. So let's break it down into a Substack. So we've put together a Substack, which is basically, for those who are wondering, what's he talking about? This is the idea of a regular, fairly meaty newsletter with articles on it. So we thought we'd put these into more sort of bite-sized nuggets. And then the idea is you can subscribe through the Substack platform, and therefore it's just so much a month. The podcast, for example, that we put out, that's for free, but we're going to then be putting, the really good stuff, more premium advice, that you're getting a little sort of monthly compliance service that's giving you help and advice. You're getting, as I say, these separate chapters and checklists and forms and templates that we've put together, as well as then sort of more regular guidance around new bits of legislation as they come through, for the cost of a few cups of coffee a month, as opposed to a sort of bigger one-off investment. So there's that there as well, if people are interested.
Wow, that's so cool. I like the idea of that, like little bits of legal advice, access to legal advice. If you're interested in listening to Peter's podcast, or you want to look at his Substack, just go to the description of this podcast episode. If you're a legal tech founder still trying to grow your brand, the reality is this: someone with half your expertise is about to out-position you. And when they do, you don't just lose reach, you lose deals, investors, opportunities, and more. I'm opening exclusive free access to a blueprint I've never shared publicly. If you want to become law firm's go-to legal tech solution, you'll need to become the leading authority. I explain exactly how in my blueprint. Go to the description of this episode to get it sent straight to your inbox now.